Hi everyone. Hello from the Batignolles, the new quartier, the new district in Paris, which used to be like a dump, which belonged to the French monopolistic train company called SNCF. And you know, when Paris was actually competing for the Olympics a long time ago, like in the early noughties against London, who eventually won actually the Olympics challenge bid. So this place was supposed to be the Paris Olympic Village if Paris had won the Olympic bid, which it didn't, because Jacques Chirac, the French president at the time, was a twat, excuse my French, but really, because he robbed a lot of money from the French state. But not only was he a robber, but he was also a very bad negotiator. So it's actually Tony, what was his name? You know, the Prime Minister from Labour, the Scottish guy, Tony. Anyway, you know who Tony Blair, yes, who was a skilled negotiator and communicator who actually won the bid. And so, therefore, the Batignolles was not changed into the Paris Olympic Village, but was changed into a sort of park, Martin Luther King Park, by the way, and in homage to our American friends. And also, it was changed, as you can see, with buildings in the back, as like some new buildings for tenants, both council estate tenants as well as private tenants. So it's a bit tense here. Because you've got a mix of population, but it's fine. It is what it is nowadays. So I come here, you know, sometimes to relax in the morning, and I just wanted to actually touch base on what's happening at the moment between France and the UK, in particular in relation to enforcement of judgments from France, for example, into the UK. As I'm sure you know, the UK exited the European Union as a member state on the 1st of January 2021. Which implied that the EU regulations, whereby I think they're called like Brussels regulations, if I remember well, there are 1 and 2. So these EU regulations made it very easy and smooth to enforce a judgment which had been handed down by another European Union member state into another one of the 28 EU member states. Yes. But these Brussels regulations, these EU regulations, no longer apply, obviously, in the UK because they exited last 1st of January 2021. So what happens now? Well, chaos is what happens. Basically, there's a total, like the new treaty, which, as far as I know, has still not been signed, by the way, between the EU and the UK. The treaty does not cover the aspects of relating to the enforcement of EU judgments in the UK and vice versa, of course. So there's basically like a legal no man's land. There's, or perhaps more accurately, there's a legal emptiness, legal void. There you go. Because we don't know. At the moment, we have to reverse back to the default setting system, which is an exequatur process whereby you can obtain the enforcement of your EU judgments in the UK and vice versa, the enforcement of a UK judgment in one of the 27 member states of the EU. So the exequatur process is pretty complicated, it's pretty expensive, and it's pretty long. So that means that at the moment, what I notice is that a lot of our clients at our law firm Crefovi, which focuses on advising the creative industries, is that whenever we've got this sort of cross-border issue and one of the parties is from the UK, what they tend to do nowadays is that they tend to revert to basically alternative dispute resolution, trying desperately to do mediation, but at the moment I can tell you that mediations are quite difficult to finalize because lots of the times the parties just don't want to be forced to pay and to pay up. So mediations are perhaps not coercive enough. Are just basically not a method which has enough coercion in itself for the basically the one of the parties to pay up and pay. So mediation, yeah, maybe, but not really, and especially with the UK, because because I can tell you at the moment it's pretty difficult to do good business with UK counterparties. So what they do is that they try to do arbitration. Why? Because it's more coercive in the sense that there's going to be an arbitrator who is going to hand down an arbitration sentence. And thanks to the New York Convention, to which, thank God, the UK is a member of, as well, of course, as the EU, it's much easier to enforce an arbitration sentence in the UK at the moment than, as I was saying, a court judgment, because there's a legal void, as I just explained. So, yeah, so our, creative clients are now looking at arbitration, and they are knocking at the doors of the likes of IFTA, the International Alliance, the International Film and Television Alliance, located in Los Angeles, which is the reference body for filmmakers and TV and film production companies. And they always have a booth at Cannes and at Berlin, at all the big film trade shows and markets. And basically they are the reference. They have a great arbitration body. I am a neutral both for England and Wales as well as France on the neutral list. The list of neutrals. Neutrals are the name you give to arbitrators. So I am an arbitrator, and in fact I am actually appointed as an arbitrator at the moment on one of the arbitrations, where one of the parties is actually from the UK. So that's what our creative clients are doing. And also what's happening at the moment with the courts is that because of the COVID-19 pandemic, things have slowed down a lot. A lot of the courts, especially in France, have been reluctant to adopt and to convert into virtual hearings, like video conference hearings. They just refuse to do it. Perhaps, for a few criminal matters which are extremely urgent, they would do a video hearing with their own technology from the Ministère de l'Intérieur et de la Justice. But otherwise, the civil and commercial matters, no. So it has to be en présentiel, as we say, so in-person hearings. But with all this, stuff happening with COVID, etc., a lot of the judges have just, called themselves sick, and therefore, the hearings are being postponed and postponed and postponed. So a dispute which used to be resolved through a court process in 1 year now can take up to 2 years to 3 years. It's just getting quite ridiculous, really. I am baffled that the French and UK justice powers that be do not understand that they need to absolutely get online, and video conference of the court hearings is the first step, really, to get there. So, and also better software, or actually creating a software for the UK, because they don't have any, to actually do the case management of the disputes. We do have a case management software in France. It's called eBarreau. But it's very complicated. It's extremely expensive. You've got to pay 320 euros just to get the key, and it's going to work, if it works, for 3 years. It only works with the search engine Firefox, Firefox. It doesn't work with Chrome. It doesn't work with Safari. Anyway, it's just a nightmare. It's just shite. Excuse my French, but really is eBarreau. Forget it. Shite. So anyway, there's a lot of improvement to be done and sophistication in terms of IT. IT tools, etc. There's a lot of room for improvement, basically, with the court system. And also there's this problem, which is at the moment that basically there's a lot of uncertainty as to how you're going to enforce your court judgment anyway in the UK, as I just explained. So yeah, arbitration seems to be the way to go, although I can tell you it's not an easy feat as well, because parties can be, you really have to, as an arbitrator, you have to be tough to obtain the evidence that you need to actually hand down your arbitration sentence. But it's a great experience. I really enjoy doing it, and I think that it's only going to develop in the future. Also because it's important for parties, for business parties, to be able to resolve their issues in a business manner, in an efficient and streamlined manner, as opposed to having to stand the bureaucracy and lengthy delays and lack of commercial awareness, as well as of the French and UK justice system and judges, etc., etc. please do read my my article about the TuneIn judgment, which I released last month, and you will see that basically, those judges are completely out of touch with reality, ready to actually kill a technical innovation like TuneIn, just because they enshrined principles on neighboring rights, which are not enshrined in all countries in the world, by the way, are allegedly infringed. So this is unacceptable, this lack of commercial pragmatism. Anyway, bye for now, guys. Bye.